Good afternoon.
Good afternoon, my Lord. My Lord, can I give Lord Leggett's references first, and then I'll try to grapple with my Lord's question. My Lord, and my Lords and my Lady, at page 481 of the record, there is a reference to the evidence of Dr. Petronella Manning Allen, and she uses the phrase air hunger to describe the respiratory distress that she witnessed.
Page
481 of the electronic bundle. And there are several references on that page alone to air hunger. And in addition, there is evidence from the appellant, paragraph 17 of his witness statement. I'll get the page reference for you in a second. And as far as expert evidence is concerned, so I've given you factual evidence so far. The expert evidence, Dr. Bola Singh, in her report at page 921. And she confirms what she says in her report, as you would expect, in her cross-examination on page 364. I promised the page reference for the witness statement of paragraph 17. That's 771. And if you the line reference for Dr. Bola Singh on page 364 is line 47. Line 47. And with your leave, I won't take you to those references unless you ask me to. My Lord Hodge, can I turn now to your question? My Lord, there are just two observations I'd like to make. The first is that AFE and DIC are not mutually exclusive, which I'm sure is not an issue between us, but I think it's important to bear that in mind when one is, as my Lord's question does, focusing on what I will describe as the causation question.
Yes.
And my Lord,
I think it's accepted that, or it's certainly your position is AFE can lead to DIC.
Yes, but my Lord, yes, I was hopefully going further and saying I hope that it's I hope that it's common ground that they are not mutually exclusive. That's just an analytical comment, but I won't seek to take that any further. My Lord asked me a question derived from page 948 and 949, and my Lord drew my attention to the very last sentence. This rare event could not have been anticipated. This, of course, is the diagnosis of AFE. In such a rare and unpredictable event, one could not be expected to have blood available in the nursing home prior to the delivery. And then my Lord drew my attention to, in view of the emergency that arose at the delivery and the resources available at the time, it is my opinion that Dr. Achong acted in the best interest of the patient, who unfortunately demised despite his best efforts. So my Lord's question to me is, well, what do we get out of that as far as, again, the causation question is concerned? So two things, or three perhaps. The first is it has to be taken in its context, and the context is how he was treating her, which he summarizes on page 947. And as I said to you before, he does so even-handedly. And we could pick it up, if I may, in the middle paragraph. Does my Lord and my Lady have it? And it's volume 3, if my Lady is using the physical bundle. 947. Dr. Achong Lau administered oxygen, etc., etc. He performed uterine fundal massage, infused, etc. Blood, hemocell, in an attempt to support circulation. He needed to administer more blood and more blood products. I'm not sure if these were available to him, but I'm aware of the difficulty of obtaining these on an emergency basis, having worked in Trinidad in that year. So he's setting the context and, of course, its limitations, but he's focusing on, so in order to appreciate what is being said at 948 and 949, that's a factual context. That's point number one. Point number two, I'd ask my Lord to go back now to 949, if my Lord is so kind. Go to the top of the page, and you would see there, and this helps us with the causation question, the extract from Williams, it says there was no data that any type of intervention improved maternal prognosis with amniotic fluid embolism. Profound neurological impairment is common in survivors, and so on. So he's saying two things there on the question of causation. He's back on data, but he's emphasizing or sharing with the reader that there is no data that points to a specific type of intervention that improves maternal prognosis if and when you suffer with AFE. That's one. And then he identifies a particular and troublesome problem with those who survive, which is, of course, neurological impairment. And then he goes on to identify, in the very last sentence, 8% of the women who are unfortunate to suffer this condition, who had a cardiac arrest in conjunction with initial symptoms, survived neurologically intact. So that's a low percentage about as far as impairment is concerned. So it's in the context of surviving. So that context provides that expert context, not just the evidence, but the literature, helps my Lord appreciate what we say is the upshot of this analysis and provides the scaffolding for what appears in the very next paragraph, which is that his conclusion is that in view of the emergency that arose and given the resources available at the time, his professional opinion is that he acted as best he could and she demised despite his best efforts. So, my Lord, those 1, 2, 3, 4, those last 4 words are your causation words, if I might put it like that. So, my Lord, that's the assistance that I can give you, walking, as it were, through 948 to 949, but of course praying in aid 947.
Thank you.
I deeply oblige, my Lord. My Lords, when we took the short adjournment, in terms of where I was in terms of my written case, I had invited my Lords and my Ladies' attention to paragraph 70 onwards. I'm not proposing to read them out or to take you through every single paragraph.
You can take it that everything in your written case has been read by the board.
I'm deeply obliged. It's worth, however, just emphasizing paragraph 80. For the overarching conclusion that we advance as far as cause of death is concerned. My Lords and my Lady already have my earlier submissions. I don't propose to repeat them. But the benefit of paragraph 80, my Lady, is that it takes on board the beginning and end of our last conversation before the short adjournment about the context in which one places the endorsement on the medical certificate. That's 81. But it allies to that, and this is important by way of characterization, Dr. Gibaud's, what we say is uncontradicted evidence about the coagulation disorder. Dr. Daisley's viva voce evidence by way of explanation and elaboration that there is and this is in a sense a partial answer to, I think, insofar as I grasp it accurately, what Lord Leggatt was taxing me on, that there's a common association between the uterus that fails to contract, described in the case as uterine atony, and clotting problems, and that it's one of the causes of DIC. And then, of course, we conclude by going back to the volume of blood loss. But more importantly, from our point of view, can I invite your attention?
That's the point against you, point 3, isn't it?
My Lord.
It's suggesting that the cause of the DIC was uterine, an atonic uterus.
With respect, my lord, no, it doesn't go that far. It says, I think, one of the causes.
Yes.
So, again, my lord,
Says it's a common association.
Yes. And so my lord was asking, the way that I understood my lord's question, about overlap. And this is another way of putting it. And my lord asked the question in relation to each of the 14 indicia, if I could put it like that. And so my lord, my reflection over the luncheon adjournment is that identifying or isolating or extracting one indicator by itself does not lend to a helpful or comprehensive analysis. It is that they ought to be taken together. But insofar as it is perfectly legitimate to say, well, which of these several criteria exist, we say that the taking of the majority of the indicia together is what led to the reasonable diagnosis, and that the fact that uterine atony is one such cause of DIC doesn't mean that it was the cause in this circumstance, because you have to, in order to come to that conclusion, consider the other causes and the other symptoms.
Well, is there any symptom that isn't explained or isn't consistent with uterine atony causing DIC is the explanation? Because we know she had an atonic uterus. That's why they were massaging her for hours after the birth.
Well, my lord, my lord has posed two questions there. The appellant's evidence was that the massaging of the atonic of the uterus was done prophylactically. That's in fact the word that he used. That's number one. And number two, there is how do I put this accurately? Sorry, my lord, I lost my train of thought in relation to the second question, the second part of the question.
I was just asking you whether there's anything on the list of signs that you went through and symptoms
yes.
that would tend to suggest that the cause was not uterine atony causing DIC.
And the one that springs to mind is the one that I gave you evidence of as we resumed after the luncheon adjournment. In other words, respiratory distress.
Well, that seems, well, I had a quick look at that. The evidence of the paediatrician was that was being suffered at 7:30, which was basically when she was dying, not immediately after the birth.
Well, Lord, can we...
If you want to show us 481, that was how it appeared to me.
My Lord, I'm happy to look at it, and I'm happy to look at the other reference that I gave you.
The reference I found
Yes, my Lord, you are
absolutely
correct. Let me just...
was that she was demonstrating air hunger at 7:30. Well, by that time, she'd had no replacement oxygen, replacing the oxygen in her blood and she'd been bleeding, for 2 3/4 hours.
My Lord, with respect, no, the evidence that I referred you to, that I just took Lord Hodge to at page 947, confirms that she had oxygen. My Lord, you are absolutely right. Insofar as my Lord is relying upon oxygenation through the administration of whole blood, that is correct. But it's not correct to say that she hadn't had oxygen administered to her.
No, she had an oxygen mask, yes.
Yes.
But her lungs could have been shutting down at 7:30 because, along with other organs, because of the hemorrhaging that had been occurring and the lack of blood.
Well,
I mean, this is not evidence that immediately after birth,
No, my lord.
she was gasping for air.
You're absolutely right. I am not making a chronological or a time point about when she suffered air hunger or respiratory distress. That's not what I'm on. I was simply trying to give my lord support for the existence of each of the features that we've already identified. So, my lord, I was simply on the proposition that 83, where Dr. Daisley gives evidence that there is an association between uterine atony as one of the causes of DIC, is entirely consistent with all of the rest of the evidence taken in the round, and that in any event, that was the sort of thing that one would have expected to see analyzed by either the first instance judge or by the Court of Appeal. But Lord, at paragraph 81, which I think is where I was on, I was inviting my Lord's attention to the fact that the administration of the syntocidan, for which oxytocin, of course, is a synonym, and uterine massage, were preventative measures. I used the word prophylactic a little while ago. But my Lord will see that that suggestion doesn't just come from the appellant, but it's supported by the evidence of Dr. Singhbol at 920 and Dr. Jabod at 946. And my Lord will see that what we say thereafter is also consistent with the level of blood loss that the measures...
I haven't quite understood. You're saying they're preventative, but
yes.
They're only preventative because they are trying to get the uterus to contract, isn't that right? And failure to contract will result in bleeding.
Correct. So it's seeking to prevent further blood loss. It's proactive in that sense.
Yeah, I mean, at 946, she was appropriately given intravenous syntocinon and fundal uterine massage in an attempt to stop bleeding since the uterus was atonic. That's Dr. Jabot's statement.
Yes, my lord.
Yeah.
Yes, that's on the page just before the one I took you to on 947.
Yes,
you're absolutely right, my lord.
Thank you.
That's what I was...
that was the reference, yeah.
And the reference to... I got a little bit ahead of myself. I was referring to Dr. Jabot's evidence about reducing the blood to a trickle. In other words, my lord, the successful application of these measures, that's dealt with in the following paragraph. Does my lord see that at paragraph 82, the reference is 695, line 16 to 21. So the question that was put to him, just for the context, the point I'm making, this is the cross-examiner. I'm on line 16 for my lord's note. I'm making is that the rubbing of the abdomen after falls did not help. Well, the note said that there was a trickle after the lady has a baby. It is normal to have bleeding. If this patient after rubbing is having a trickle, I think that's a good response. Is the context. For
what stage was that? What time is it talking about there that there was a trickle?
He is referring to, I'm going to have to try to pinpoint that because he says that's what he read in the notes, and I don't have the cross-reference to the notes of the nurse's notes. But it is certainly after, and I'll ask Mr. Rudder to assist me, it is certainly after the two initial, as it were, blood losses. In the very early stages, you have, as my lords will remember, 500 milliliters and 300 milliliters. So it is after that, but I'll try to pinpoint that in time in a second. So, my lords, that's the only additional material that I wanted to invite my lord's attention to as far as cause of death is concerned. and without, I don't propose to repeat by way of a summary any of my earlier submissions, but what I would ask my lords to take on board is that the analytical exercise that we continue to engage in was not undertaken by the courts below, and that approach is not consistent with the proper evaluation of expert evidence in accordance with the cases that we've cited in our written case. Can I turn now with my lord's leave to the appellate court's other fresh finding, which is that the appellant did not, contrary to what he deposed to in his evidence, diagnose AFE. And so, my lords, you can get a clear indication, it will shorten your note if you look at paragraphs 85 onwards of my written case. So, paragraph 85, the common evidence is the evidence of all of the experts, Dr. Jabbour, Dr. Singh-Bola, and in fact, Dr. Daisley as well, is that AFE can only be diagnosed clinically. Perhaps presumptively is the right way of putting it. Now, as far as the appellant is concerned, what has happened in the Court of Appeal is that he has an adverse finding made against him as to credibility and persuasiveness, is how it's put by their lordships in the Court of Appeal, solely on the transcripts. So we say, and no flattery is intended, my Lord Hodge, but if one applies the Beacon criteria for appellate intervention, that it is not open. So this is not a question of an overturning of a finding of a first instance judge. This is a fresh finding by the appellate court with the benefit only of the transcript. And it's helpful, I think, to look closely at the Court of Appeals analysis for this. So can I invite my lords to paragraph 93 of the Court of Appeals judgment. Where his lordship and the Court of Appeals say that the findings referred to above belie his contention that he diagnosed AFE. His alleged diagnosis of AFE was made quite soon after the hemorrhaging began, but no effort was made to obtain blood from Mrs. Lezama until 6:40 at the earliest. Lord, just pausing there, well, you know we challenged that. In cross-examination, he was challenged by Mr. Marcus as to why, if he was treating the patient for DIC secondary to AFE, he waited until 7:30 to administer whole blood. his answer, in effect, was that blood was difficult to obtain. If, in fact, he had made such a diagnosis, then his failure to move with alacrity to obtain blood and to call for assistance is even more compelling of negligence. He alleged that he had five previous cases of AFE. If that is true, he ought to have had more than a fair knowledge.
I mean, is that finding right, that he had 5 previous cases and had been successful in saving 4? That was his evidence, was it?
Yes, my lord.
Yes.
I think we...
And do you challenge the finding that if he did think it was AFE, that was all the more reason for him to take urgent measures to try to get blood and call for assistance?
No, my lord, I don't think that I can. My answer to that is the answer that I gave you earlier today, which is that 2 things happened. In taking them in reverse, or taking them in chronological order, is that he treated with Mrs. Lezama in the way that both Dr. Jabot and Dr. Bola described, between 4:53 and 5:45. In other words, fundal massage, syntonosen, hemocell, Ringer's lactate, all of the material that we looked at in our statement of facts and issues. We say that the evidence is that Dr. Manning Allen went to the hospital to seek both syntocinon as well as blood. We've discussed that already. We also say that at 6:40, blood was taken for cross-matching, and no blood having been obtained from any other source, including the blood bank, he asked Dr. Manning Allen and Mr. Lezama to go to St. Clair, which is another private maternal clinic, to see if they could obtain blood there. And his evidence
immediately did?
Yes.
So there's no reason to suppose that if that had been done 2 hours earlier, it wouldn't have had the same result?
There is no reason to suppose that that was not, in fairness to him, ever put to him. There was no such suggestion. The normal and the common evidence among the experts is that the primary source of obtaining blood is from the blood bank.
Well, that's somewhat undermined by his evidence that he had this relationship with Sinclair, and that seems to have been a part of the obtaining of the blood after he asked for it. It was in his witness statement.
No, milady. I'm not. I'm assenting to the. I'm assenting to the observation. I am dissenting to the proposition that one statement undermines the other. Another.
Well, it is quite simply this.
Yes.
If you have a clinician who knows he has a relationship with a particular medical centre, which he subsequently relies on, in order to get the blood,
yes,
all the more reason to have done it earlier, knowing what he did.
Well, milady, can we just tease that out so that when my lady says knowing what he did,
yes,
can I submit respectfully that the one thing that he could not have known, having regard to the exchange between myself and Lord Hodge about the evidence of Dr. Manning, is whether or not she would have obtained the blood. In other words, he could not have known that she would or would not have in advance. So that in any assessment of his conduct, it can't be looked at through the rearview mirror, meaning identifying what in fact happened if he could not have known it at the time. That's the only point I'm making.
There's no evidence that he gave any thought to trying to get any blood until 6:40, which is when he first took a sample for cross-matching, which was the first thing he needed to do. That's what he should have done So when there was severe bleeding after birth?
Well, my lord has already my submission on the evidence from Dr. Manning on that.
Well, there's no evidence that you've shown us that he had any part in that, whatever happened then.
Well, my lord, no, that's not quite right. I mean, Dr. Chang's evidence is that he attended on the basis that Dr. Manning Allen, this is in his witness statement, Dr. Manning Allen had asked him to do so, and that she was doing so with the consent of the appellant. Yeah. So that my respectful submission is that, and I've made this before, so my lord, forgive me if I just say it one last time, and I promise not to repeat it. Everything that Dr. Manning Allen did, she did for and on behalf of the appellant for the benefit of Mrs. Lezama.
I mean, that's an inference I can see you might want to draw and may possibly be able to draw.
Yes.
But I mean, there was no suggestion in his evidence, was it, that he sent Dr. Manning Allen to get blood?
No, there is. I can't go that far. The only thing that I could say, the only thing that I can invite your attention to, is that he was, from the very beginning, administering Syntocinon, and Dr. Manning Allen went to the blood bank to obtain additional supplies of Syntocinon, so that if one had to consider them as competing inferences, the two would go together, if I could put it like that. But my lord is absolutely right, and I cannot say to this board that there is direct evidence from the appellant along the lines that, and I know my Lord Legate says my pleading point goes nowhere, but had the case been pleaded, how do I put it, more transparently, then there might have been. And that applies with the greatest respect, Lord Legate, to each and every aspect of this case. That had we not been derailed by the pleading going in a particular direction, the evidence which was tailored to meet that pleaded case, and of course tailored and did so successfully.
Was he cross-examined about this at all? I mean, was he asked, was it suggested to him he should have taken steps earlier to obtain blood? Earlier than the successful step that he did take? If so, then he then had an opportunity to deal with the point. If not, then he didn't.
Well, my lord, of course, it depends on the how the challenge was framed.
Well, one might have thought that in the situation, if he had taken any steps to try and obtain blood sooner, he would have been the first thing he would have wanted to draw to the court's attention. But
well, my lord, again, I'm going round and round.
Yes,
I'm not, you know,
you don't
I'm
know
not here to
what he was asked or not.
Yes, and I have, you know, I am doing the best I can, given the case that was presented to the appellant at first instance. That's really where we are.
Of course.
And it would be improper for me to enter into too much, well, to any speculation at all, if I may, my lord. But Lord, we are just going to check on the cross-examination point. So, my lord, I just have a sense that yes. My lord, I drew your attention. I was addressing the point as to the fresh evidence with respect to the diagnosis of AFE. And I think I drew your attention to paragraph 91 a moment ago. Am I right? But I did not draw your attention to what preceded it, and I apologize for that. I kind of went to the end. So can I ask for analytical purposes for us to pick it up at paragraph 78? And so the learned judge of appeal not having had the benefit of an answer to this question by the first instance judge, says it seems to me that if AFE was his working diagnosis at the time of the emergency, it would have affected his treatment. The question is whether it was reasonable in the circumstances to have made such a diagnosis, if in fact he did make it. Reasonableness is to be judged against the Bolam standard, that is to say whether such a diagnosis would have been accepted, etc. In the cross-examination of both Dr. Singh, Bola and Jibod, it emerged that a significant number of the symptoms were present. In those circumstances, in agreement with them, it was reasonable for him to have diagnosed, and in that I agree with Dr. Jibod that it would have been reasonable to put AFE on the certificate as a cause of death. So that we come back now to my lady's point about what was on the death certificate. But the evidence of Mr. Lezama, as well as his entry, the appellant's entry, on the death certificate as PPH, DIC, and stillbirth, although that's not quite the order in which they appear, which is DIC, PPH, and stillbirth. He says, without any reference to AFE, raises doubt as to whether he did in fact diagnose AFE at the time of emergency. So pausing there, my respectful submission is that it does not raise any doubt. It is, with respect, perfectly neutral. It doesn't go one way or the other. He goes on to say, indeed, he was challenged on this issue of fact by Mr. Marcus in cross-examination, and having reviewed the statements, etc., I do not accept his contention that he diagnosed it. In my judgment, this is a conclusion he came to, sorry, I'll read it again. It is my judgment that this is the conclusion to which he came after sober reflection. His explanation at paragraph 28 as to why he did not put AF in the test is unpersuasive. So, my Lord, and he does not say at paragraph 28 that it was a definitive cause, but that was one of the conditions which can occur. And he sets out his answers. So here, the judge of appeal, and I'll just pick up the answers and then I'll make my submission. He says, answer to one, I made a presumptive diagnosis. When I'm writing, I am not a presumptuous person. I was not going to write a presumptive as a cause of death, right? I wrote the things that were open and objective for everybody to see, but both diagnoses led back and tie back if one were to see my note or discuss with me what may have been the cause of death. So DIC, stillbirth, etc. And then I wrote postpartum hemorrhage, but that is a direct cause of death. It's a head, and he explains the form and so on. And then his lordship's analysis of that and the previous observations is this. The allegation of a presumptive diagnosis was quite a retreat from his confident diagnosis of AFE at paragraph 17 of his witness statement. So, my lords, I say with the greatest respect, adjectives, and that's using a neutral word, like retreat, confident, and so on, really place the appellate judge in the arena, listening to the evidence of the witness. And if that's not what happened, then all he is doing is getting an impression derived from the transcript. And so we say with the greatest respect that that's not Beacon compliant. It falls to that end of the spectrum which prohibits an appellate court from substituting its view, because that's what happened, bearing in mind that the first instance Judge Rahim came to no view at all. So he is substituting his view, and he is, with respect, not drawing inferences here, which would be the proper and acceptable province of an appellate judge or appellate court. He is, in fact, making primary findings of fact. And we say that those are A, impermissible, and B, wrong. So I apologize for rushing you down to 91 without giving you that context. My Lord, in the interest of even-handedness and comprehension, can I go back, my Lord Legate, to see, in other words, provided my Lord happy for me to do this, I'm going to take you to the cross-examination, if that's all right? My Lord, can we pick it up at page 661? 661. My Lord, line 47 onwards, he's asked, would you accept for me that giving blood at 7:36 was late in the day? Do I accept that the giving of patient blood was late to do so? If it was late, the timing was late, but there's a reason the blood was given at that time. No, but just please answer my question. The blood did not arrive before that time. The timing was late. Well, yes, one can use that phrase. Timing was late. And so that is an answer as to timing. And there is another passage. And just for completeness, can I take you to page 666? Again, at the very bottom, lines 46 and 47. Well, let me pick up the question from line 40. Can I again, for completeness, my Lord, just point out this is re-examination. You'll see that at the very top of the page, line 8. And so he's asked in re-examination, I just want to know, you're about to tell us the reason why the time the blood was given at 7:36, sorry. Let me start again. I just want to know, you're about to tell us the reason why the blood was given at 7:36. Can you tell us? Well, first of all, at 5:15, when the patient basically went into shock, my first reaction was I had to, given my prior knowledge, I had seen the blood wasn't clotting. I had already formulated that presumptive diagnosis. I knew I had to get as much fluid into this patient as possible. She had one IV line, and we had to get up another IV line. And then in terms of any sort of blood or blood products that we sent for, we had to cross-match to the patient. So that means I had to take a vial of blood to send. In that kind of situation, it takes a long time to insert an IV line. In terms of getting a specimen, it may have taken 20 to 30 minutes even. And when the line was in, we had to work in getting on as much fluid and blood substitute into that patient as possible. So the hemocell, the ringers lactate, and we talked about Stanley's at a Sunday night and so on. And then in the middle of that page, the court asked him a direct question, introducing it with these words. Are my lords with me? 27, 28. The court has three questions. The first is this. Now listen to the question carefully. If you don't understand the question, you can ask me and I will attempt to rephrase it. In your medical opinion, if the 2 units of blood were hung initially from the moment of first bleeding, which would be somewhere between delivery and 5:15, would the likelihood of survival of the deceased have increased? I'm only asking your opinion. And his answer is, I honestly do not believe that the 2 units of blood would have made a huge difference. And then over the page, you will see between lines 12 to 19, a reference to pale being blood, not clotting, and so on. And that was a reference that I promised to give you, my Lord Legate, some time ago. So here it is, 688, lines 13 to 19. So, my Lord, just to digress just momentarily, that question and answer as to the impact of the blood on the causation question, and I'm going to try to say this slowly, as far as we can tell, is the only direct evidence elicited from anyone on the issue.
Remind me, how much would 2 units of blood be?
Are they litre each?
Lord, I can double check. Sometimes the units are in 500 mils, and sometimes they're in 1 liter. But I will double check, and we will give you an accurate answer.
Thank you.
My Lords, in the limited time that I have left, I think I'm right in thinking I have 15 minutes. My Lords,
you are entitled, if necessary, to use up some of your reply if you're pressed.
My Lord, as
but on the normal run
yes.
of things, you've got 15 minutes.
Yes, deeply obliged, my Lord. What I was going to say is that I don't think my Lords will, and my Lady will find it particularly helpful for me to repeat what I have in my written case in relation to, I'm going to put my hands up, in relation to negligence. There are three different aspects to it. We cover it at length in our written case. It might be a legitimate criticism that we covered it at excessive length, but I won't get into that. So that what I would like to do is to try to pull the threads together on the basis that you have read it, as my Lords have told me that you have done. And I will say perhaps a little something about the respondent's case in anticipation of what it is my Lady
You're fully entitled to rely on your written case.
Yes.
And we will, of course, take it into account. And you should not lacerate yourself about it being too long. The written cases in this appeal are a good deal shorter than some we see.
I'm deeply obliged, but I'm most grateful. But there is one aspect of the case that I would ask my Lords and my Lady in the quiet reflection of your study to have regard to. And that is the circumstances which were at play on this Sunday evening on the 6th of April, 2003. And they are supported by the evidence. They are that, A, this is a Sunday night at a facility with limited supporting facilities, such as there was no ability, for instance, to test blood. And so that the evidence has been in each case when the clinician needed to access additional resources about which Dr. Jabod and Dr. Prasad and the courts accepted, and this is important, the courts accepted it is not clear whether these resources were available, and in particular, it is not clear how readily available blood and whole blood, platelets, cryoprecipitate, and so on, how available these were. And the reason why that's an important context for determining not just the questions as to breach of duty, but causation, is because it affects the identification of the question or the issue that one formulates in order to give an answer to those questions. So that the appellant's answer in response to the question posed by the learned judge as to whether the administration of the 2 units of blood that were available ultimately from another institution that he was able to get them from would have made a difference, is part of that overall context. But it also points to the questions similar to and along the lines that my Lord Legott has been asking me about in the course of my oral submissions. Well, where is the evidence from the appellant that this is what he did and did not do? Now, leaving aside my pleading point and leaving aside the way that the case evolved, we say that it was incumbent upon the respondent to adduce their positive evidence not just directed to breach in the way that the findings have evolved, but similarly as to causation. Because their riposte to the complaint made at first instance and before the Court of Appeal was, as my lady put to me earlier, that this was a standalone allegation or standalone allegations. That can be the correctness of that proposition can be tested in this way. If one looks at, and the easiest way to find it is just to go to the Court of Appeals judgment, rather than go back to the pleading itself. The Court of Appeal, in answer to the allegation, and I'm on paragraph 217 of the bundle. That's the Court of Appeals judgment where the particulars are set out. The Court of Appeal says, in relation to 10.4, we accept the argument advanced by the appellant that sufficient syntocinon was administered to stop the bleeding. So one would have thought that that would have been the end of that standalone argument or that standalone conclusion. But when you go to see how the Court of Appeal dealt with that, I apologize for not being able to pick it up quickly. You will see that that has morphed I think this is right. Let me just double check. That has morphed into whether or not Mrs. Lezama's hydration was adequate. So what doesn't look anything like a medication issue has now become whether her hydration was adequate and whether the appellant asked for help. That's paragraph 88. Leave out paragraph 89 and paragraph 90. And so we say that those are unsatisfactory bases. Taking all together, these are unsatisfactory bases for a professional medical man to find his conduct impugned, not simply on the basis that he was negligent, and not simply on the basis that his negligence caused the death of one of his patients, but that he was untruthful about it. And so he is faced with that finding that he was untruthful about it. In other words, he was untruthful about his diagnosis of AFE, not at the level of the first instance judge, but at the level of the Court of Appeal. So we say, with great respect and drawing the threads together, as follows: that Mrs. Lezama's condition was unequivocally and incontestably that of cardiovascular collapse, respiratory distress, coagulation defect, and bleeding. That the correct approach to the expert evidence explaining and identifying those symptoms, first of all. Secondly, determining whether or not the conduct of the appellant was or was not negligent. And thirdly, and most importantly, determining whether or not those symptoms, those conditions, or the appellant's alleged negligence caused Mrs. Lezama's death, all had to be approached on the basis of the analytical template that I have already sought to advance before my lords, in reliance upon several of the cases with which this court is very familiar. The respondent did not, on each of those steps, i.e., the condition she suffered, the breaches, but much more importantly, the causation approach, discharge evidentially the case made out against, the case alleged against the appellant, which was regrettably confused by what their real case was. And their real case from start to finish was that she was a gestational diabetic, known to be a bleeder, and that because the appellant knew that, he ought to have had blood at the ready. So with those respectful submissions, we ask this court to allow the appeal in the way that we've set out in our written case. My lord and my lady, unless there are any more questions, I was hoping for an easy one, but
I have one.
that was just to put a smile on my lord's face.
I have one question for you, Mr. Benjamin. It may be completely tangential, but it will clear my mind. In the law relating to autopsies in Trinidad and Tobago, who may request an autopsy, and does the next of kin have a veto?
Second half first. Members of the family can always ask for a private one, but as far as a publicly funded, we have, don't quite have the NHS, but we have an established public health care system. That's a matter for the responsible health officer. So the CMO or the district health officer would be the person who would put in train that, that request. And yes, the clinician can initiate it.
I have a related, another question in that area, which is whether there is not an obligation to report a death in these sort of circumstances to the coroner.
My lord, I did look at that, and my researchers suggested not, but I'm certainly prepared to give it another go. I'm not going to suggest to you that I did an in-depth piece of research. It did occur to me. I looked at it very sort of superficially, And if I can get there...
It's mentioned sort of in passing somewhere, I can't remember where,
yes.
one of the judgments. That,
yes.
Is it?
So, my Lord, my honest answer will be, I don't know, but I will come back to you, if I may. My Lord.
Mr. Benjamin, thank you very much for your clear submissions.
Thank you very much for your questions. No, I do mean that, by the way. It's not advocates. I mean, you know, outcomes are one thing, process is another.
Sit down.
Good afternoon.
Good afternoon.
I would like to begin, if I may, with something that my learned friend would have said. And that really is that he referred to the notion of the balance of probabilities. And I would like to begin with asserting, and I think this should not be in dispute, that the balance of probabilities is the standard of proof, and there is no notion of the balance of probabilities. So that causation, which my learned friend has been heavily questioned on, must nonetheless be proved on a balance of probabilities. Any suggestion that the claimant respondent had an obligation to prove causation beyond a reasonable doubt or with 100% scientific certainty is incorrect.
Well, I think you can assume you're pushing at an open door in that regard.
Yes, I assumed so, but I did want to respond to that because it came up more than once. So that the balance of probabilities as referred to by the trial judge, I respectfully begin by saying was correct. The fact that he did not make a specific finding as to whether the appellant diagnosed the patient with AFE, I also want to suggest that when his judgment is read in its entirety, he did not make a finding on that because he did not think he needed to. It was apparent on the appellant's own evidence that he did not diagnose Karen Lezama with AFE. He does not say it to the family that are present in the room on the 6th of April 2003. He does not share the working diagnosis with Dr. Manning Alain, whose role in this is something I will come to because she is at times referred to as a friend. There is a suggestion in the appellant's cross-examination that she was not helpful to him, and yet today she has been elevated to the role of agent, so that I will be considering that in some detail next. But insofar as the trial judge had before him the appellant's evidence is clear. He didn't diagnose Karen Lezama with AFE. He later says that is the cause of her death, and somewhere in the course of submissions, it is elevated to a diagnosis. But there is nowhere on his evidence or his pleaded case where he details the circumstances in which he diagnosed her with it, where he shared the working diagnosis with those who were assisting him in attempting to resuscitate her. And then it does not make it onto, most notably, the medical certificate, and it does not prompt him to order an autopsy. All of that evidence is indisputable, all of it incontrovertible. And in those circumstances, the issue doesn't even arise before the trial judge. He would have been well within his rights to consider that it is not even a matter that he had to decide, because it so clearly was not put before him on the evidence of the appellant. What the Court of Appeal goes on to criticize the trial judge for is not determining whether it could have been the cause of death, which, as the board has correctly identified, is relevant to the issue of causation more than it is to the issue of liability. It's not irrelevant to liability, but it is by far more relevant to the issue of causation. So that when the Court of Appeal, at the invitation of the appellant, and that really must be made quite clear, the appellant invites the Court of Appeal to reverse findings of fact of the trial judge. My learned friend has said today it does not beacon compliant, but the truth is what they do not appreciate is the outcome of the exercise. They invited the Court of Appeal to revisit the findings of fact. They just don't like the conclusion. And so they want this board now to undergo the same process, but to come to a different finding. I don't think it's fair to say it's not beacon compliant. I'm going to say it is an unusual circumstance, and I say it's unusual because I have actually looked for authorities where there have been reversal of findings of fact by the Court of Appeal of a first instance judge, but an affirmation of several of the findings of fact, so there are concurrent findings of fact, and an affirmation ultimately of the decision, which I recognize puts the appellant before the board in a difficult position, because they wish to complain that there has been an interference with the finding of fact, but they do not wish that you reinstate the original findings of fact, so that it is actually a quandary. But for me, it is not a quandary, and I hope it is not a quandary for the board, because the Court of Appeal, by inquiring into the issue of whether the appellant diagnosed AFE at all, actually displays fairness to the appellant, increased fairness, because they did not have to do it. They went through an exhaustive review of the evidence to give him any possibility, or as my learned friend has used several times, scintilla, any scintilla or shred of evidence that would support this allegation, this assertion that I diagnosed Karen Lezama with AFE. That assertion, as I said, really grows at the Court of Appeal stage, but is not something that appears frontally or comprehensively or substantively on the evidence as taken before the trial judge. And the assertion by my learned friend that, it's his credibility. Well, yes, that cannot be denied. It is his credibility. But as the board has extensively questioned my learned friend, the death certificate is a matter of credibility. He endorsed on the death certificate those causes of death which he considered to be correct. And he endorses as well, he does not endorse AFE. And he has the opportunity, because he is questioned at length by learned senior counsel, Mr. Marcus, on this issue. And he is given every opportunity to give a comprehensive reason for this. And my learned friend says he made a joke. He made a joke. He says he's not a presumptuous person, so he did not include a presumptive diagnosis. Neither Mr. Benjamin nor I were present in the trial, but I do not regard it as a joke on the transcript that if you wish to avoid liability and if you wish to demonstrate to the family that you have done all that you can, then you certainly would not wish to utilize the word presumptuous in cross-examination as to why you omitted what you now assert was the only and primary cause of death. So that it is a very serious matter indeed, the issue of whether the cause of death was AFE, and it certainly cannot be denied that the appellant does not give any evidence to the trial judge, and accordingly there is no evidence before the Court of Appeal or the board that he diagnosed it, shared that diagnosis, and treated or acted upon that diagnosis.
I see the point about him not sharing the diagnosis, but are you saying he gave no evidence that he did diagnose AFE? Because in paragraph 15 of his defence, he avers in very clear terms that the deceased suffered AFE.
So what he does, please, my lord, is he says that is what she had and that is why she died.
Yes.
But what he does not say is that I diagnosed it, unless he means that by diagnosing, he diagnoses it retrospectively, because contemporaneously it is not on a note, it is not in a medical report, and it is not shared with the attending physicians, nor does it appear in a death certificate.
Well, clearly, certainly among the board, I have not read all of the oral evidence he gave, but did he never assert that he'd made a presumptive diagnosis at the time?
He says in response to questions put to him during cross-examination that it was a presumptive diagnosis. And
made at the time?
Yes.
Yes, well, there is evidence then.
Well, in that sense, yes.
And I think he said it in his witness statement, didn't he?
Yes.
Yes, he does.
So,
my submission...
He made this assertion in evidence at the time.
A bare assertion, yes.
Yeah, yes, but I think there's more force in the point that he didn't share it with the family, and he didn't share it with Dr. Manning Elaine, and
Dr.
perhaps
Chang.
Significantly, he didn't share it with Dr. Chang, who came in to help out and would surely have asked, "What am I dealing with?"
Yes, my lord.
Yes.
But on the assumption that he did diagnose AFE, I've heard the board ask my learned friend this question, and while I begin by saying that I don't think it needs to be answered, because I don't consider that my friend has met the burden of persuading this board to in any way set aside or inquire into any of the findings of the Court of Appeal. I will say that assuming that it is AFE, I am not certain why my learned friend believes that it assists him. If it is AFE, if he did diagnose AFE, then he did not treat it. This reference, the appellant admits that uterine massage is not a treatment for AFE.
Have you got the reference for that?
I do. It is in my case as well.
Oh, if it's in your case, I can check it.
But yet, the position has been taken that it was done prophylactically. It was done preventatively. It was done for 4 hours, and it was done to treat a condition that he says it could not treat. If it was the primary cause of the DIC, then there is no explanation from the appellant as to why he did not treat the AFE, but instead prophylactically treated the uterine atony and treated the PPH, which he does endorse the PPH and the DIC on the death certificate ultimately. But there is no explanation as to why he does not move promptly to treat the AFE. That if he had diagnosed it and chose not to share it with anyone and chose not to treat it, then in fact the negligence is greater than it is on the current findings of the Court of Appeal and the trial judge, because his own experience, according to his evidence with AFE, was considerable. He was in fact the doctor before the court who had the most experience with AFE. Dr. Jabode, who my learned friend has referred to as having comparable experience to that of Dr. Achong Lau, had seen only one case, and Dr. Singbola frontally admitted that she had seen no cases, having had admittedly the least experience of the three. So having seen 5 cases and having saved 4 of them, though details are not provided, and having stated that he made the diagnosis, he does not provide any explanation as to why he did not proceed to treat it.
Well, I thought the gist of the case for him put is that there's nothing he could have done if that was the underlying cause.
That is the causation argument that he then makes, but there is no, in fact, his defense says that he administered sufficient blood and blood products. So he doesn't say in his defense that there was nothing that he could do. He admits that administration of blood and blood products was necessary. He just says he gives enough of it.
Well, for those reasons, I think that Mr. Benjamin put the crux of his argument on the causation point. That's really what he puts at the forefront of his case. He says that, well, whatever, even if, although he doesn't admit it, but even if the defendant was negligent, you didn't prove that treatment would have been more likely than not to have saved him, particularly if the underlying cause was AFE.
Because the DIC is the circumstances that everyone is agreed upon. Although I do say that it's impossible for the appellant to distance himself entirely from PPH. He cannot do so. He placed it on the medical certificate. So though much has been stated about it's not enough blood loss, it's not a severe enough PPH, nonetheless, it is what he had already.
Well, he described it as massive on the death certificate.
Yes, but not since. On the inevitability of death, because that is what the causation argument on AFE has become. It is an inevitable death. And there just isn't evidence before the trial judge or the Court of Appeal or this board to support inevitability.
No, but he says he doesn't have to prove inevitability. You have to prove that it's more likely than not that she would have been saved if appropriate treatment had been administered.
Yes, well, and I don't agree with my learned friend that I must prove that.
Well, why not?
And I will go into that immediately. So that what the burden that my friend is suggesting that the burden was wrongly placed on him, that the burden was wrongly placed on the appellant by what he considers to be a flawed pleaded case. And the flawed pleading case is not actually canvassed in the appellant's case and has already been dealt with by the board today, and I don't propose to go into that unless you require me to, because we start with the position that those are standalone subparagraphs, and he had notice of Mary Singh Bola's report, Dr. Mary Singh Bola's report. He had the opportunity to put in expert evidence of his own. The case is frontally disclosed on the witness statements. There is no reliable argument or relevant argument that can be made that he did not know the case that he was facing. The respondent is actually in the worst position because the respondent relies, as they are entitled to, upon the death certificate, the same death certificate that is only attacked in writing by the appellant in his defense in the proceedings. So the question of who is really taken by surprise arises, and I say that it is actually the respondent. So that for the respondent, my friend has said it's not his burden. If it is his burden, it was discharged. I say it was always his burden. If he says that the AFE is the cause of death, not having said it anywhere else, he must prove on a balance of probabilities that it is the cause of death.
Well, he doesn't have to do that because you have to prove that the negligence caused death.
Yes, I have to prove that negligence caused death, but I don't have to prove that AFE caused her death.
No.
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 But you have to show that either it's likely that she did not have AFE, and that in those circumstances it's more probable than not that a proper treatment would have saved her. Or you have to argue that even if she did have AFE, it's more likely than not that a proper treatment would have saved her. And you have to prove.
Yes, my lord, but I also,
those things.
If we can all agree, and we must, on the case that that she suffered DIC, whether that was caused by PPH or AFE, she suffered DIC. She was not clotting. The only way that she could clot is if clotting factors were given to her. Everyone is ad idem on that, including the appellant. And the appellant says, I gave her blood. I gave her enough blood. That is his defense. So to suggest that I must disprove his defense cannot be correct. His defense is that the administration of blood and blood products is a treatment for what she was suffering. That is consistent with what we said, because whether it is induced by the PPH or induced by AFE, it is the same condition, disseminated intravascular coagulopathy. And so she had to receive the clotting factor. She had to receive blood and blood products, and she does not receive enough, and she does not receive them in time. And so we prove causation, because that is what causes her death.
You have to support the inference that if the treatment had been, if he'd acted reasonably and appropriately, he would have procured blood at a certain time earlier, and one would expect some analysis of that, of when, and that blood administered at that time would make it more likely than not that she would have survived. And there really was very little evidence in that area, if any.
But that is actually one of the areas on which the experts agree, my lord. They agree that she should have received blood and blood products earlier, and more of it.
Yes.
Including the appellant's own expert witness.
They do. That's the negligence. What there's very little on is whether having received it earlier would have saved her in this situation.
My lord, the failure to treat the DIC, in my respectful view, is quite clearly on all of the evidence what causes the death, including that of the appellant. He simply would like the court to accept that it was AFE that induced the DIC and that there was nothing that he could do because it was AFE. But in truth, the DIC is treatable. On his own evidence, it is treatable. AFE is treatable on his own evidence. On his evidence, he successfully treated it 4 out of 5 times. So that for him to say that there is no inevitability to it, and the statistics placed before you are just not reliable. 20 to 90% is an incredibly wide range. It offers no precision. 80% as put in cross-examination from a source that whilst it is accepted by Dr. Mary Singh Bola, it is not really put in evidence by the cross-examiner. And then the appellant himself says 50%. But on his own qualitative statistics, I saved 4 out of 5. The truth is none of those statistics are relevant or easy for this court to rely upon. But everyone is also agreed, the experts are agreed that only an autopsy could have confirmed whether she died from AFE. And that autopsy is not ordered. And it is not ordered by the appellant. Now, the appellant says, and we have disputed, that the family did not want the autopsy. They say different. But at any rate, he doesn't tell them he doesn't tell them about his alleged diagnosis of AFE, so that even if he asked them about the autopsy and invited their consent, it was not informed consent. I will come back to causation, as I know it is the issue that mainly concerns the board, but I would like to, there are some other aspects that I'd like to touch upon before that, unless the board prefers that I address on causation now.
No, I think the board will be happy to hear you on causation tomorrow morning if you want, but I think you need to take on board that the gravamen, at least of the oral submissions that have been made today, have been on causation, and also that the basic rule in a negligence case is that the claimant has to prove not only negligence, but also that had there been no negligence, the adverse result would not have occurred. Now, as I understand it, your case is that a combination of PPH and DIC of itself, well, you're sort of saying it's obvious that the recruitment of further help, the administration of blood products, etc., and adequate hydration would make it more likely than not that the patient would survive, because postpartum hemorrhage does occur and people do survive. But you've got to look at, see what evidence there was led in relation to that. And secondly, you've got to address the question, if the court were to conclude that on balance of probability that this was a circumstances of AFE, what evidence was there that the period to take these measures caused the death? But this is a matter you can discuss tomorrow morning.
Yes, and I will.
And as I understand, just to put another thing in for you to consider overnight, as I've understood it, but this may be wrong, and if so, please correct it. If it's AFE, it's not, and possibly DIC too, it's not the only mechanism that blood loss in those circumstances causes death ultimately, if you don't do something about it. But a coagulation disorder of the kind they're talking about, I believe has the effect, is this right, that it causes lack of clotting externally, as it were, so there's bleeding, but clotting internally so that organs can be damaged by blood clots.
Yes, that is...
So it's not just a simple matter of saying, well, if you deal with the blood loss necessarily, you know, that addresses the problem.
Yeah.
There's more to it than that.
If there was evidence that she sustained any type of organ failure.
Yes.
But there isn't.
Right, well, that's what you will be helped to fill.
No, and it may well, my understanding, it may be wrong, was that if there was DIC, that might require even more blood replacement in order to get out of the system.
Yes.
That which was causing the problem, as it were.
And to actually begin clotting.
Mm. But anyway, these are matters you can address us on tomorrow.
I intend to.
Thank you.
But I wish to take you to two issues very briefly. The first is Dr. Manning Alain. I don't want to repeat what the board has already said in relation to the evidence that my learned friend relies on for the submission that she requested blood allegedly at the instance of Dr. Achong Lau and did not obtain it, because my understanding of the board's interpretation of the evidence is that it is consistent with my own, which is that that piece of cross-examination does not establish that she requested blood at the instance of Dr. Achong Lau and did not obtain it. And unless I'm wrong on that, I will proceed to deal with the issue in a different way, which is there is a suggestion coming from my learned friend that it could not, in response to something that Lord Hodge would have questioned him on, which was the issue surrounding, did she make a general inquiry, and suggesting that it could not have been so in the emergency circumstances that pertained. And in the words of my lady, it cuts both ways. If Dr. Manning Aline is to be regarded as having been responding to an emergency situation, then, and she is there as a pediatrician and a friend, then certainly Dr. Achong Lau cannot avoid judgment on the same basis. It is his emergency. It is his patient. And the question that the board specifically asked was, it seemed that counsel appeared surprised to be informed that inquiries had been made by Dr. Manning Aline at the blood bank, and and that was agreed to. And it was a surprise because it isn't part of the appellant's case. It isn't part of his case that he made a request of the blood bank, or that he asked Dr. Manning Aline to go to the blood bank, or that when she returned, he inquired from her whether she could go to the blood bank. Very simply, he doesn't make a request from the blood bank, and he didn't know that she had done so, or it doesn't form part of his case. So that he makes no request for the blood bank, and the duty was his. The emergency was his. So to suggest that she failed in some way, or that is determinative, or that allows the appellant to assert that blood was unavailable is, in my respectful submission, entirely wrong. And shouldn't be allowed. But more importantly, it is not the appellant's case. The appellant's case, from his defense, is, I had access to blood, I got blood, it was enough. That is what he says. The fact that he eventually does get blood from St. Clair, and that he demands that blood, because those are his words, I demanded it. He didn't say I requested it and I had to persuade anyone. He said I demanded it and I received it. It was always available to him to obtain blood during the crisis. My friend's words, not my own. The blood was indicated because there was an ongoing DIC, according to the appellant. He says he observed it. It was DIC. Whether it was caused by AFE or it was caused by PPH, blood was needed. But more importantly, if it was caused by AFE, blood was more needed. I say that respectfully because DIC, if you're treating the underlying cause, it's harder to treat the underlying cause of the AFE than it is the PPH. The PPH, triggered by uterine atony, treated by uterine massage, is being treated. He says prophylactically, but that is what was happening in the room. The uterine atony was being treated to stop the PPH, which in turn could stop the DIC, or at least could slow it down so that clotting factors could be replaced. With AFE, you have an option, and not many. One of them is treat the DIC and treat it quickly. And you treat the DIC by replacing clotting factors, which segues into the fluid resuscitation that was ongoing. The fluid resuscitation that I'm referring to is the administration of Ringer's lactate and Hemocell. the Ringer's lactate, a crystalloid, Hemocell, a colloid, both of them being given simultaneously. It doesn't arise on the evidence, but I say that. So that the crystalloids and the colloids that were administered over a considerable period of time, neither of them contain clotting factors. Both of them are intended to try to achieve hemostasis, the stabilization of the pressure and the volume of the blood.
I don't think that's in dispute from the question that I put to Mr. Benjamin.
Yes. And they are administered through the IV access, one of which failed or was not working, as observed by Dr. Chang on his entry into the room. So that the fluid resuscitation, which was a treatment that was necessary, but was not the administration of blood and blood products, which was more necessary, was not being overseen by an anesthetist. It was something that Dr. Achong Lau was doing with the assistance of nurses in Stanley's maternity clinic, which you have been invited by his counsel to find to be inadequately resourced. Doesn't have enough. Doesn't have enough of this and it didn't have enough of that. Well, it didn't have an anesthetist either. And one was needed because it is an anesthetist that assists in fluid resuscitation. It is an anesthetist that assists in resuscitation. And that is precisely what Dr. Chang does when he enters the room. And this will go to causation. It is uncontradicted that Dr. Chang is able to make a positive contribution to her condition. He comes in, he observes that an IV access is not working, he rectifies it. He begins to put the ABCs of resuscitation, and he begins to put the matter in order. It is just too late. Why did he not call for an anesthetist? There is no explanation given. There is instead an attempt to piggyback on the efforts of Dr. Manning Alain, who I have already submitted to the court is sometimes treated as a friend, sometimes treated as an agent, and sometimes treated as somebody who didn't help very much at all by Dr. Achong Lau. But she calls for Dr. Chang in the same way that she attempted at the very beginning of the crisis to enlist the aid of Dr. Ajit Kuravilla. And she brings him, and he is willing, and Dr. Achong Lau turns him away. Again, another unexplained circumstance. More than any other breach, the failure to call for assistance, in my respectful view, cannot be challenged and has not been challenged before the board. There is evidence that Dr. Chang's intervention and assistance helped. Had he been called earlier, it is more probable than not that he would have been able to substantially assist and the outcome avoided. The board has the benefit of the appellant's case and the respondent's case. And you've already indicated you've read it. But I do ask that the board give particular consideration to the appropriation by the appellant of the efforts of Dr. Manning Alain in the two instances, one in the request for assistance, and the second in relation to the blood. It isn't proper, and it doesn't arise, that it can be demonstrated or portrayed that the actions of Dr. Manning Alain were in any way the actions of Dr. Achong Lau. What it does demonstrate is that she knew better, it seems, the steps that needed to be taken. And instead of conferring with Dr. Manning Alain and enlisting her aid and counsel, it appears that he didn't cooperate with her. And that includes, I respectfully submit, the ordering of the autopsy, which is her final attempt to ensure clarity and some type of outcome that would make sense. And it is an attempt that I respectfully submit was rejected by Dr. Achong Lau. And it was rejected in circumstances where everyone acknowledges that the AFE could only be confirmed on the conduct of an autopsy.
It may be something you want to assist the board with tomorrow morning, but as to that statement, AFE could only be confirmed on an autopsy. No doubt you have references. I'm not asking for them now, but...
I will.
Thank you very much.
I will produce them. My learned friend began with the miscarriage of justice in an effort to persuade the board that you can or should interfere with the concurrent findings of fact, because there are indisputably concurrent findings of fact. But respectfully, Lord Kitchen requested that he be taken through the steps, and I, having taken a note of my own, I don't believe that we were taken through those steps. Having reviewed the appellant's case, my own respectful submission is that it has not been demonstrated to the board that there is any basis on which the board should interfere with the judgments of the Court of Appeal and the judgment of Justice Rahim at first instance. And it has also been, both judgments have been conflated before the board, so that you have been presented with the findings of the lower courts, which in some cases but it was attributed more to one rather than the other. It is somewhat confusing as to whether the appellant has in fact identified those concurrent findings clearly and demonstrated why the court should interfere with those of the Court of Appeal. I say this because in the directions that we received, it was particularly noted that the concurrent findings should be properly identified and addressed in that way. There is, in my respectful view, no miscarriage of justice that has been submitted on to the board that would justify intervention. And insofar as the board has indicated that there may not be a concurrent finding of fact on causation, I will show tomorrow that there are some concurrent findings of fact that go to causation, and there are some that may not, that the Court of Appeal has solely come to, and I will address both in that way in my submissions tomorrow, specifically on causation.
I mean, in relation to the findings that you say aren't concurrent findings of fact, as an appellate court, we would in any event wish to look very carefully at whether to interfere with an evaluation of those facts, would we not?
Yes, yes, my lord. I have heard my learned friend, and it is in the case, and it was made in submissions before the Court of Appeal, this concept of the failure of the lower courts to ask the right question. I struggle with it because I do not understand what the criticism comprises. And there has been a great deal of criticism that has been advanced to the lower courts, that they have failed to ask the right question. They have failed to, according to my learned friend, they have failed to conduct the conversation we're having today, or the exercise that we're conducting today. And I truly just do not see it the same way. That is not my understanding of how evidence is treated with. It isn't a conversation. And it is, in terms of the timing of this case, and the manner, the year in which it was done and the time in which it has started, there has been a growth in medical negligence cases in Trinidad during that time period. But insofar as this case brought several experts before the court, then I would ask that the court note that, to a large extent, these reports were, to the best of the abilities of all participating at the time, compliant with Part 33, our expert sections. And I say that because for the first time today, I've heard my learned friend advance criticism of Mary Singh Bola, Dr. Mary Singh Bola. She has been criticized for her lack of experience. She has been criticized for her report not being compliant. She has previously been praised, actually, by the other courts for, though despite her inexperience, having presented a comprehensive report and having responded during cross-examination reasonably to the questions put to her. So we come to her concessions. Dr. Mary Singh Bola's concessions that much have been made of amount to no more than the conduct of a responsible expert, acknowledging that factors that were present, clinical factors present in this case, could be referable to either AFE-induced DIC or to PPH-induced DIC. And I believe that she also acknowledges that in her report. So she's been criticized for not being precise or detailed on those factors in her report. But if you place Dr. Jaboud's expert report side by side with Dr. Mary Singh Bola's expert report, you will find that Dr. Mary Singh Bola's expert report is more comprehensive and more balanced. And that may be attributable, as is Dr. Prasad's, but that may be attributable to the instructions. So I would ask the courts to note, and I will take you to the references tomorrow, the instructions that were given to the experts were, of course, given by the attorneys who were requesting the reports of them. And the letter that accompanies the request for the report from Ms. Dindial to Dr. Mary Singh Bola provides her with the witness statements of all parties. Dr. Achong Lau's witness statement, the claimant's witness statement. It asks the questions objectively. It provides the notes, comprehensive documents. Dr. Jaboud's letter of instructions, and I recognize that this was a point that was not argued before the lower courts, but I raise it because the basis on which you are being asked to interfere is that the evaluative exercise is flawed. These experts were not properly critically examined. This is what you're being told. Well, Dr. Jaboud's report arises out of inadequate instructions. They can be called nothing. One witness statement is given to him, and that is Dr. Achong Lau's witness statement. And then he is provided with the agreed bundle of documents. So he gets notes and he gets Dr. Achong Lau's witness statement. But more importantly, in the body of the letter, he is told, the appellant, in that case the defendant, diagnosed AFE. He is told this. He is told it without being alerted to any of the controversies, the fact that PPH and DIC were endorsed solely upon the medical certificate, that there may have been a subsequent, that it's presumptive. The same evidence Dr. Achong Lau gives in cross-examination is not shared with his own expert. So that his expert begins at a disadvantage. He begins at the disadvantage of only having one aspect of the narrative put to him because he doesn't get any glimpse of the claimant's case. In the example of Ms. Dindial's letter of instructions, Dr. Mary Singh Bola is given Dr. Achong Lau's witness statement. She knows what his defense is because it's disclosed there. Interestingly, even though Dr. Jaboud does not receive the comprehensive instructions of either Dr. Mary Singh Bola or Dr. Prasad, I neglected to mention that Hamel-Smith would have instructed Dr. Prasad, and the letter is again very comprehensive. Dr. Jaboud nonetheless says, I would have called for assistance. He says it. More blood and blood products needed to be administered. It's so apparent that even without all of the evidence, he is able, from his experience, from his knowledge, to say it is what should have been done. So I ask the board not to entertain any criticism of Dr. Mary Singh Bola in the way that it has been presented, because it cannot be that some of her concessions and some of what she gives as evidence is being referred to as the appellant as not being taken into consideration by the Court of Appeal, not being relied enough upon, but then her expertise and her quality of report is being questioned, and then juxtaposed with Dr. Jaboud's rather inadequate instructions and his own brief report, that I asked the court that there is just no basis to say that this evaluative exercise was not properly done. I think the courts did, and I think the board can accept that the courts did quite a lot and the best analysis that they could on the evidence that was before them. So insofar as the errors in the evaluative exercise that my learned friend relies upon are necessary to persuade this board to interfere with the concurrent findings of fact, then I say they have not brought themselves within that exception. This segues into the Court of Appeal's reliance on Dr. Mary Singh Bola, which my learned friend referred to, but called it a mere recitation. Said it was not an analysis. This is not a recitation if a court quotes from the evidence or summarizes the evidence of a witness and says, well, we accept it. They've accepted it. They do not need to grapple or quarrel with the witness. They are entitled to accept the evidence of Dr. Mary Singh Bola, and they're entitled to accept it in the way that they did, where they say quite clearly she may have made concessions, yes. That's not, no, we're not disputing that, as Lord Hodge rightly pointed out. I believe in a very early stage, it could have been a reasonable diagnosis to make. The Court of Appeal has said so. It's a reasonable diagnosis that could have been made. But the Court of Appeal prefers Mary Singh Bola's evidence that it was more likely PPH-induced DIC, which again raises another point. My friend called it common. There's no evidence that AFE is common. It's rare. It's rare. It's rarer than PPH-induced DIC. And so rare, and the mere fact that it's diagnosed initially on clinical factors, because there is as yet no clear blood test when someone remains alive. It can be confirmed on an autopsy, but whilst alive, there are no clear tests that will tell you that they are suffering with AFE, so clinical factors must be relied upon. That doesn't make it a presumptive diagnosis. There are conditions in which all you have are clinical factors. That doesn't mean it's presumptive. It can still be your diagnosis. You may be wrong, you may be right. It's a question of the reasonableness of it. So the clinical factors for AFE, some were present. The Court of Appeal says they accept the evidence of the experts that it may have been a reasonable diagnosis to make. They equally say he didn't make it, and that it may also, that they prefer the evidence from Mary Singh Bola that it is not likely. And Mary Singh Bola is supported by the appellant. The appellant's clear evidence when he endorses the medical certificate, his contemporaneous evidence, DIC, PPH. The court asked more than once, was there any factor present, any factor that would have made it, that would have ruled out, I'm going to use that term, and if I'm wrong, I apologize, that would have ruled out PPH-induced DIC. In other words, was there any factor present that was consistent with AFE that would not have been consistent with a PPH-induced DIC? Is that the question properly framed? Lord Legat, I think it was your question.
Yes, I did ask that question.
Is that properly framed? Because I would like to answer it. No, there was no factor. There was no factor.
Was there any evidence as to how PPH induces DIC? Can you recall?
No, because I don't believe it was in dispute.
Thank you.
In terms of the, I do want to briefly come back to the IV line. I notice that it is not something that any consideration has been given to, but the non-functioning IV line, as identified by Dr. Chang, which has not been challenged, as he arrives in circumstances where he has also made a clinical observation that there is a low urine output. That is not something, I respectfully submit, that can be ignored. That is a clinical observation. He is there on his legs. He is one of the treating physicians in an emergency circumstance, but he clearly goes into a very organized mode. He observes the IV access, he rectifies, he observes her low urine output, and he comes to the medical conclusion that she is not properly hydrated.
Well, Dr. Lowe attempts to put forward an alternative explanation, doesn't he?
I'm sorry, what was that, Lord Legat?
He attempts to put forward an alternative explanation, which could have been kidney failure.
Yes, renal failure. The renal failure, I have reviewed the notes. I do not see it. I don't see that any expert was instructed on renal failure, including the appellant's own expert. And I heard my learned friend use the term evolution or evolve. And I do respectfully submit that it seems that the appellant's explanations evolved. But if he was concerned about organ failure, if he felt that she was going into renal failure, he did not ensure that she was taken to an ICU. You have been asked to consider that it was Sunday, and our hospitals do not close. And I am not asserting that the public healthcare system in Trinidad is without difficulty, but it is erroneous to suggest that that blood was not available from the blood bank, or that there was evidence to that effect. And it is erroneous for it to be suggested that there were no options because the hospitals were open. We know this because Dr. Manning Aline, in yet another one of the efforts that she made on the 6th of April 2003, went to the hospital to obtain syntocinon, which she obtained. It was functioning. So you have a patient in distress. You're talking now of renal failure as an alternative explanation, but you made no effort to have her admitted to an ICU, and you made no call to an anesthetist at an early stage. In fact, you made no call to an anesthetist at all. You waited until Dr. Manning Aline said to you, "Can I bring this anesthetist?" And you said, "Okay." I don't want to belabor this because the board would already have extensively questioned on it, which is the volumetric blood loss. 500 plus 300, 800, much has been said of it, the cc's. But there is other evidence, as the board has already identified, and that is the evidence of Brian Lezama as to what he observed. But there is also evidence from Dr. Manning Aline as to what she observed.
Where do we see that evidence?
The evidence of Brian Lezama was already referred to by the board, which was the river of blood.
Yeah, we've seen. I think
Yes.
the Court of Appeal refers to the evidence of the father.
Yes.
But it was Dr. Manning Alane's evidence that you. I wonder if
Yes,
you've got
I
a
apologize.
reference.
I will obtain that reference.
Yeah.
But even if the appellant's estimate is what he says it is on a volumetric basis, he considered it to be PPH. He considered it to be a postpartum hemorrhage, and a large one.
But by definition, once it's over 500, it is definitively PPH.
It is PPH.
But at the same time, the symptoms to which Mr. Benjamin referred us and the table which we were shown would suggest that a loss of less than a litre of blood shouldn't have a profound effect on blood pressure at all.
Yes. But it did. So it's either his estimate was wrong, or it's peculiar to the patient that is there, But at any rate, it clearly did, because he treats it accordingly. The uterine atony is a fact.
Well, I'd certainly find it helpful to see what Dr. Manning Elaine's take on what she was observing was. So those references would be very useful. And if you are to refer to passages and evidence, it would be very helpful if you have the references to hand as you refer to them. Thank you.
I apologize. I didn't anticipate having to make that response.
Am I right in thinking, and also perhaps could you check this reference if it exists, that Dr. Boller gave evidence of a study that clinicians tend systematically to underestimate the amount of blood loss?
Thank you, my lord.
I think I saw it in the passage of her cross-examination that she referred to it.
And I will.
Thank you.
I do want to just reiterate briefly, just to end that point, that it is the finding of the appellant that it was a postpartum hemorrhage.
Yes.
So that any arguments as to whether it could be at this stage are of no relevance and should not be entertained.
I don't think the appellant is arguing otherwise,
Very grateful.
that there was a postpartum hemorrhage.
And on the respiratory distress, the board has already considered the timing of that, and it does come later. I would ask you to look to the agreed facts. I will provide the precise references as well, but I think it's more of an omission. There isn't a precise time proposed in the agreed facts as to when respiratory distress would have occurred. And in fact, insofar as that evidence comes from Dr. Manning Elaine, it has already been placed quite a long way from the beginning of her distress. And so just to close for today, I know that causation will be what I am required to submit on tomorrow. In brief, the appellant has not, in my respectful submission, been able to, or should not be able to persuade the board that you should set aside any of the findings of fact of the Court of Appeal or interfere with their decision, which I respectfully submit is in all respects correct. Unless you have any additional questions for me, I'm ready to close today.
Is this a convenient place for you to hold? And are you comfortable that you can get through the rest of your submissions by 12:30 tomorrow?
I think I can.
In that case, we'll adjourn at this point.
Thank you.